let me put it to you very quickly, take it in order. I suggest that we look at, first of all, what are the tort changes that we need to restore fairness. And the next thing we have to look at is how do we pay for those changes and also provide the industry with a level of profit that they need to carry on business in Ontario. When we look at first-party benefits, we have to look at three things in the following order. The first thing is, are there benefits that can either be eliminated or reduced? The second thing is, are there transaction costs that can be reduced? And if you eliminate benefits, you automatically reduce transaction costs to some degree. And the third thing is, how do we eliminate assessments? We know that medical assessments in the province of Ontario is an enormous cost to the industry. And we also know that the amount of money being spent on assessment costs is disproportionate to what's at stake. We have to bring back the notion of proportionality when we talk about both transaction costs and assessment costs. And where it doesn't pay to assess a claim, we have to look at another way of resolving that. Now, we can get into specifics, but Ken, it would take a long, long time. But if we took it in that order and took a very methodical approach to that, I think that we would find literally hundreds of millions of dollars in savings.
Thank you, Richard. Now being mindful of, we have one more question. Mindful of time, be quick.
This is for Richard. My name is Bob Dorn. I'm from Alberta, and I kind of take a little bit of issue with regard to, it's a matter of just increasing premiums because it's a far more complex situation. For example, in Alberta, we have a judiciary that is deciding the compensation for injured people who, I have to respectfully say, seems to operate in a bit of a bubble, and is virtually immune from any attack from the public with regard to premium increases and that type of thing. And then you have the government who actually regulates our business, who is very prone to and sensitive to arguments from the public about premium increases. So I think it's rather simplistic in my mind that you would think that it's just simply a pricing problem, because I think it's far more complex than that. And what else do you do? Because I think it's a generally accepted concept that minor injury compensation, or people who have minor injuries are overcompensated, and people who have catastrophic injuries or very serious injuries are undercompensated. So it gets kind of complex, and I don't think it's quite as simple as all that. Could you comment?
Yes. Well, first of all, let me make myself abundantly clear. I don't believe that we're going to solve what's wrong with auto insurance by simply increasing premiums. There are other things that we have to do. In terms, what my comments about pricing were that in 2003, there was a perception that we had a crisis in insurance because of pricing. And what happened was that the margins were allowed to disappear and ROEs hit rock bottom. That was a matter of pricing. It had nothing to do with the other issues that you raised with claims costs. Claims costs weren't out of control. Claims costs weren't unpredictable, either in bodily injury or accident benefits. Certainly bodily injury claims costs were, as I said, linear and relatively stable. Accident benefits costs perhaps less stable but still linear in that time. The only variable was ROE, and again, the reason is because of pricing back then. While there is no simple solution, the answer to that is that if we didn't have precipitous decreases in ROE, we wouldn't need precipitous raises in premiums to offset that ROE. The other problem that you face when you talk about government and regulation, the other problem that you face that I think is a more difficult problem is how does the industry respond more quickly to changes in the market with a cumbersome rate approval process that you have. That's a difficulty that I think is worth addressing as well. You've got to be able to respond to market conditions in a more timely way so that you don't get caught in a situation where the bottom has dropped out and you have to implement changes that either are unpopular with government or the public or that demand reform every 3 to 5 years.
Alan, any comments?
I just want to pick up on your comment about, I think you said the Alberta situation's not that simple, and I think it's a very good point because what we learned in the evidence of the Alberta cap case is the government studied this for a lengthy period of time. They got the input from all kinds of stakeholders, and the evidence was that they looked at 10 possible alternative systems or reforms, from complete public system like in BC, a complete no-fault system, changing deductibles, changing the definition of minor injury claims, adopting the New South Wales model, which we all, of course, are familiar with. I don't know what that is, but the point is they looked at 10 different options, and this is the one they came up with. And every time you have one of these constitutional challenges, you're really second-guessing the legislature, and the court is really, overriding the legislative prerogative and saying, we're not going to give deference to the legislature. And to me, one of the most interesting aspects of the appeal when we argued it was one of the judges was essentially asking the question, well, isn't it enough just to come up with a scheme that makes sense? No, you're always going to have people with various opinions who disagree with it. And how are you ever going to come up with a system that everyone agrees to? Isn't it enough that you've taken into account all these considerations, and you've come up with a scheme that makes sense? And I think that is really the key question in these charter cases, which is, should the courts be overturning the legislature when the legislature have done their best to take into account all these interests all the way through, and they've come up with a scheme which may not make everyone happy, but it balances all the interests across the board.
But just to respond to that, there's an important...
You don't have a right to respond.
But I will. Thanks. There's an important legal principle at stake here, too, that I don't think we take into consideration. Where you seek to limit one's rights, the language of what you use to limit those rights will be interpreted strictly. And where an interpretation can favor the person's rights that are compromised, it will be interpreted that way. And I think the message that I wanted to get across in my initial remarks is that, what we see happening in Alberta, or what we see even in Ontario with what's happened in Ontario, judges aren't readily prepared to accept impairing traditional tort rights. They find it fundamentally offensive. And all I'm inviting you to do is, in the process of reform, consider that these tort rights are not simply an accounting entry, but that there are public policy issues at stake here, that there are traditional access to justice issues at stake here. It's been recognized as an access to justice issue. And turn to other ways, like addressing what's wrong with first-party benefits in Ontario. Turn to other ways to fix the problem before you start attacking those reforms that really are more vulnerable to either judicial challenge to the public, constitutional challenge, backlash from groups that I represent. I think we'd have to take that different approach.
Do we have room for time for one more question, Greg? No more time? Okay. I want to mention, as I was boarding my flight here yesterday, I did see an ad. Many of you may have seen the same ad. It's by HSBC, and it reads, "The world would be a dull place if everyone agreed on everything." So I'd like to ask you to join me in thanking Richard and Alan for showing that our world of insurance is not a dull place. Thank you very much. Thank you, Richard.
Thanks, Randy.
Thanks a lot.
I think this session has traditionally been one that we can all enjoy because we all take interest in the cases that set precedent in our industry. And Alan, you helped us in a thorough understanding of the logic of the courts, and you assured us that logic and reason should prevail. Richard, I really commend and thank you for your courage to come into a room where you clearly and calmly express your views, and you understand that they're generally adverse to the majority of people in the room. So thank you very much for your courage in this, and thank you for your moderating of this particular session. And on behalf of all of us, I present you each with a certificate here This certificate, of course, gives a contribution to the Women in Insurance Cancer Crusade. So thank you. Okay, now we're going to move right into the next session, which is Global Trends in Distribution.